The ask came between the main course and dessert. That is the detail I return to most often, not the words themselves, but the timing. The deliberate, practiced placement of it. After the wine had been poured twice. After the conversation had warmed enough to feel safe. After my mother had asked about my apartment, and my father had asked about my promotion, and we had constructed, together, the temporary architecture of a normal family dinner. Then my father set down his fork, and the architecture collapsed. "Lauren," he said, "your mother and I need to talk to you about something serious." I already knew what was coming. Not in the way you sense bad news, the vague premonition, the tightening of the chest, in the way you know a route you have memorized, precisely, completely, with full knowledge of every turn. I set down my own fork. I folded my hands in my lap. I looked at my father across the table with the expression I had been preparing for 3 weeks. Open, attentive, neutral. "We're in a difficult position," he said. "The business, it's been struggling. The expansion in 21 was more expensive than we projected. We've exhausted the business line of credit. We need real capital, not a loan from a bank, from family." "How much?" I asked. My mother reached across the table and put her hand over mine. $200,000, she said. "We know it's significant, but Lauren, we sacrificed everything for you, your education, your opportunities. Everything we built for you. You owe us this." That's not manipulation, that is just the truth of what family means. I looked at her hand on mine. I looked at my father. I looked at the table, the same table I had eaten at my entire childhood, in the same dining room, in the same house in Naperville, Illinois. That I had grown up believing represented my parents' careful, honest, hard-earned life. "After everything we did for you," my father said. "After everything we gave up." "Dad," I said. He stopped. "Why was $380,000 moved out of my college fund and into your personal account?" The rain continued against the glass. No one at that table said anything for 7 full seconds. And in those 7 seconds, I watched my parents' faces do something I had never seen them do before: synchronize. Not in warmth. In the specific, unmistakable frequency of 2 people who have just realized that the conversation they prepared for is not the conversation they are having. My name is Lauren Mercer. I am 36 years old. I am a senior financial analyst at a wealth management firm in Chicago, which means that reading financial documents is not merely something I am capable of. It is what I do, professionally with precision, for 47 hours a week. My parents, Richard and Carol Mercer, own a mid-sized landscaping and grounds management company in the western Chicago suburbs. My father founded it in 1994. It employs, at its current size, approximately 38 people and services commercial and residential accounts across DuPage and Kane counties. I was their only child. I grew up knowing that the business was the center of our family's financial life, that everything circulated around it, that decisions were made in reference to it. That my parents' moods on any given evening were a reliable indicator of its quarterly performance. I also grew up knowing, or believing I knew, that my parents had established a college savings account for me when I was born, a 529 plan. They mentioned it at intervals throughout my childhood with a particular pride. "We started saving the year you were born. You'll graduate without debt. That's our gift to you." I graduated from the University of Illinois in 2010 without debt. I had always attributed this to the 529. I had never, until 5 weeks ago, looked at the 529 records. The reason I looked was not suspicion. It was professional obligation. I had been reviewing my own financial documents as part of an estate planning process. I was updating my will and powers of attorney, something my firm strongly encourages for anyone over 35, and my attorney asked for a complete financial history, including any accounts that had been opened in my name during childhood. I requested the historical records from the 529 administrator. What came back was a document I read 3 times before I called my attorney back and said, "I need to reschedule. Something has come up. The account had been opened in 1988, the year I was born. It had been funded consistently through 1998, regular deposits, compound growth, a well-managed balance that by 2003 had reached $420,000. In March of 2004, when I was 15 years old, a single transfer had moved $380,000 from the 529 into a personal checking account registered to Richard and Carol Mercer. The remaining $40,000 had been left in the account. My 4-year degree at the University of Illinois had cost, at in-state tuition rates in the mid-2000s, approximately $68,000 in direct educational costs. I had graduated without debt. On $40,000 and a series of grants and academic scholarships that I had applied for myself in my junior year of high school, because I had been told, in the fall of 2004, 7 months after the $380,000 transfer, that the college fund was not as large as we hoped, and I should do my research. I sat with that timeline for a long time. Then I made 3 phone calls. The $380,000 had moved in March of 2004. The business records I requested next would show exactly where it went and what it had funded. And it was not what my parents had told me. The first call was to my attorney, Diane Osai of Osai and Partners in Chicago, who handles my estate planning and who is the kind of person who does not react to information with emotion, but with the next logical question. "Do you have access to the business incorporation records?" she asked. "I can get them," I said. "Get them," she said. "Illinois business records are public documents." I pulled the incorporation filing, the annual reports, and the registered agent history for Mercer Grounds Management, LLC, from the Secretary of State's database on a Tuesday afternoon in my apartment. The company had been incorporated in 1994. It had undergone a significant capital infusion in 2004, equipment purchases, a facility expansion, the acquisition of 2 competitor accounts that would later become the foundation of its commercial division. The expansion had been funded, per the business's own financial disclosures, by a private capital injection from the owners. March 2004, $380,000. I called Diane back. "It went into the business," I said. "Okay," she said. "That tells us the purpose. Now we need to understand the legal structure of the 529 account at the time of the transfer." This was the detail that mattered most. A 529 college savings plan, established by a parent for a minor child, has specific legal characteristics depending on the account structure. The account owner, typically the parent, retains legal control of the funds. This means a transfer, while potentially ethically problematic, is not automatically illegal. What makes it legally significant is whether the funds were represented, in writing or in the context of any legal proceeding, as belonging to the beneficiary. Diane reviewed the documents for 48 hours. Then she sent me a memo with 4 paragraphs and a conclusion. The conclusion read, "While the transfer itself does not constitute theft in the criminal sense under Illinois law, the subsequent representations your parents made, specifically the documented financial aid applications submitted in your name in 2004 and 2005, which listed the 529 account balance at its post-transfer value and described it as an educational asset, constitute material misrepresentation on federal financial aid documents. This is a matter of federal financial aid fraud with potential civil and criminal implications." I read that paragraph twice. Then I opened my own college application file, the one I had kept in a box in my closet for 15 years, because I am, professionally and personally, a person who keeps records. Inside, the FAFSA submissions from 2005 and 2006, my parents' financial disclosures. The 529 account listed, both years, at $40,000, not at $420,000, not with any notation of the $380,000 transfer. Not with any disclosure of the business capital infusion, $40,000, As if that had always been the balance. As if the account had simply grown modestly, and that was the full story. I sat with the FAFSA forms for a long time. I thought about the scholarships I had applied for, the grants, the 3 part-time jobs I had held simultaneously in my sophomore year. The semester I had lived on $180 a month in discretionary spending, because I was managing my finances as carefully as I knew how and I had believed, genuinely, completely. Without suspicion, that this was simply what responsible students did. I put the FAFSA forms in the folder. I called Diane. "I want to know everything we can do," I said. "All of it, every option." "I know," she said. "I've already started." She had the 529 records. She had the business incorporation timeline. She had the FAFSA filings. And she had a federal financial aid fraud memo from her attorney. She didn't call her parents. She didn't confront anyone. She waited for them to come to her, and they did, with a $200,000 ask and 30 years of rehearsed guilt. Stay with me. In the month before the dinner, my parents called me 4 times. The first call was casual, checking in. My mother asking about my apartment renovation. My father mentioning the business in the oblique way he always does when he is building toward something. The second call was warmer. My mother said she had been thinking about me, that she missed having me closer. That family was everything. The third call was my father alone, which is unusual. He talked for 22 minutes about the business, the expansion costs, the interest rates, the difficulty of the current commercial landscaping market. He did not ask for anything. He was laying groundwork. The fourth call was the dinner invitation. "Sunday," my mother said. "Come home, we'll make the lamb." They make the lamb for significant occasions. I noted this without comment. I also noted in those 4 weeks what I was not doing. I was not spending the money. I want to be precise about this, because it matters for understanding who I am and what this situation actually required of me. The $380,000 that had been moved from my college account in 2004, plus 32 years of compound growth at a conservative estimated rate, represented a substantial theoretical sum. Diane had calculated the current value of those funds, had they remained invested in the original 529 portfolio, at approximately $1.1 million. I was not thinking about the $1.1 million. I was thinking about the FAFSA. I was thinking about the federal financial aid applications, submitted in my name, that had listed a deliberately understated asset value, allowing me to qualify for need-based grants I would not have received had the full picture been disclosed. I was thinking about what it meant that my parents had structured their financial records in 2004 and 2005. Around my eligibility for aid, I did not technically need, not because they wanted to help me, but because they had already used the money that was meant to help me. And they needed the gap not to show. I was also thinking about the $200,000 ask. Diane had run the numbers. The business was not in crisis. It was in a period of reduced profitability. Margins had compressed. One major commercial contract had not renewed. The expansion debt service was real. But the business was not failing. It was not, by any reasonable financial analysis, in the kind of distress that required emergency capital from an individual family member. It was in the kind of position that requires a bank loan and a restructured payment schedule, which meant the $200,000 was not actually about the business. It was about something else. What that something was, I would understand more completely only after I attended the dinner and listened carefully to how the ask was framed. I arrived at 6 p.m. I brought wine. I helped set the table. She sat down to dinner already holding every card. And when her father set down his fork and began the conversation he had been rehearsing for weeks, she let him finish every sentence. Because the longer he spoke, the more precisely he was describing what they had done. After I said it, "Why was $380,000 moved out of my college fund into your account?" My father looked at my mother. My mother looked at my father. And then they both looked at me with the expression of people who have just discovered that the conversation they were prepared for has been replaced by one they did not anticipate. My father recovered first. He is, at his best, a composed man. Where did you hear that? The 529 records, I said. I requested the full account history 5 weeks ago. Lauren, March 14, 2004. $380,000, transferred to your joint checking account, ending in 4471. The same month, the business records show a $380,000 private capital injection for facility expansion and equipment. My mother's hand, still on mine, withdrew. That money was ours, my father said. We were the account holders. We had the legal right to move it. You did, I said. That's correct. You were the account owners. The transfer was legal. He relaxed slightly, the particular relaxation of someone who believes they have identified the limits of a problem and found themselves inside the safe zone. But the FAFSA filings from 2005 and 2006, I said, listed the 529 balance at $40,000, not at $420,000, not with any disclosure of the transfer. The relaxation stopped. The applications were accurate, my mother said. The balance at the time of filing was $40,000 because you had moved $380,008 months earlier, I said. The legal question is not what the balance was. The legal question is whether the disclosures on federal financial aid applications accurately represented the family's financial assets and recent material transactions. They did not. We were advised, my father started. By whom? I said, because that's a conversation I'd like to have documentation of. If there's a professional who told you that a same-year transfer of $380,000 from a designated educational asset did not require disclosure on federal financial aid applications. I need to know their name. There was no name. We all knew there was no name. My mother looked at me for a long moment. I watched her recalibrate, watched the version of this conversation she had prepared dissolve and be replaced by something more careful, more defensive. We gave you everything, she said. Your whole life, everything we built. You built the landscaping business in 2004 with my college fund, I said. I understand that. And I understand the position you were in. The expansion opportunity was real. The timing was difficult. And I was 15 and couldn't have done anything about it even if you told me. I understand all of that. Then, but you didn't tell me, I said. You told me the fund was smaller than expected. You let me apply for need-based grants I didn't qualify for. You let me work 3 jobs my sophomore year, managing a budget I would not have needed to manage. And now, 32 years later, you are sitting across from me asking for $200,000 using the language of sacrifice. The rain against the glass, the candles burning. My father looked at his hands. Lauren, he said, we are your parents. I know, I said. That's why I'm here. That's why I drove to Naperville on a Sunday instead of having this conversation through attorneys. He looked up. You have attorneys. I have an attorney, I said. Her name is Diane Osai. She has reviewed everything I just described. And she would very much like to discuss next steps with your attorneys present. She had driven to Naperville with a full legal file and a retained attorney and the FAFSA forms and the business records and the 529 history, and she had still shown up with wine and helped set the table. Because she is not her parents, she operates differently. Stay with me for what she actually wanted, because it was not what you might expect. Diane filed the formal legal notice the following Wednesday. Not a lawsuit, not immediately. A formal demand letter, sent to my parents' home address and to the registered agent of Mercer Grounds Management, LLC, outlining the documented facts, the applicable legal framework, and the requested resolution. The letter was 14 pages. Its core argument rested on 3 pillars. First, the 529 transfer and subsequent FAFSA filings, under 20 U.S.C. Section 1097, making false statements on federal financial aid applications, is a federal offense carrying penalties up to 5 years imprisonment and $20,000 in fines. The statute of limitations for federal financial aid fraud is 5 years from the date of discovery, not 5 years from the date of the violation, under the discovery rule. I had discovered the discrepancy 5 weeks ago. The clock had started then. Diane was careful to state that we were not filing a criminal complaint. We were noting the exposure. Second, the compound value of the diverted funds. The $380,000 transferred in 2004, calculated at a conservative 7% average annual return over 20 years, represented a current theoretical value of approximately $1.47 million. This was not a claim we were asserting in full. Diane was explicit that the account had been legally owned by my parents, and the transfer was not theft. But the figure established the scale of what had been redirected from my future, and it informed the context of the $200,000 request I had just received. Third, and this was the element my parents' attorney, a man named Gerald Park, who had handled their business legal work for 15 years, told them he had not anticipated there was a second account. Diane had found it not in the 529 records, but in the business financials. A dormant savings account at a credit union in Wheaton, opened in 1996, listed on the business records as a capital reserve account. It had not been mentioned in any of the financial disclosures my parents had made when they raised the subject of their current financial position. Its current balance, $94,000, undisclosed. Uninvited into any conversation about hardship, Gerald Park called Diane on a Friday morning. "My clients would like to explore a resolution," he said. "Of course," Diane said. "We'd like that too." The resolution meeting took place at Diane's office in the Loop on a Thursday afternoon, 3 weeks after the dinner. My parents arrived with Gerald Park. I arrived with Diane. We sat on opposite sides of a table, not unlike the one in Naperville, but without candles and without lamb and without the performance of a normal family dinner. My father looked older in that room than he had looked at the dinner table. My mother held her purse in her lap with both hands, the way people hold things when they need something to anchor them. I looked at them and I felt not triumph, not anger, not the hot satisfaction that I think people expect from this kind of moment. I felt grief. The specific, clear-eyed grief of understanding someone completely for the first time. Gerald Park outlined their position. The financial pressure was real. The $94,000 reserve account existed but was intended as a contingency. The FAFSA situation had been, and this was his word, inadvertent. They had not sought to defraud the government. They had not thought through the implications. They were not financial sophisticates. Diane listened to all of it. Then she outlined ours. The settlement required 2 months to finalize. The terms, as agreed between our respective attorneys and executed in a formal written agreement. My parents would make no further requests for financial assistance from me, in any form. For a period of 10 years, a clause Gerald Park objected to and my father ultimately accepted in silence. The $94,000 in the Wheaton Credit Union account would be used to address the business's most immediate debt service obligations, eliminating the stated basis for the original $200,000 request. My parents would engage a licensed business consultant. We provided 3 names. Diane had vetted all 3 to conduct a full financial assessment of Mercer Grounds Management and develop a 3-year stabilization plan, the cost of which they would fund themselves. And one additional term, my term. The one I had asked Diane to include, and which she had described as unusual but not unreasonable. My parents would provide a written letter, signed and notarized, acknowledging that the $380,000 transfer had occurred, that it had funded the business expansion, and that the college fund I had been told was smaller than expected had, in fact, been substantially redirected. Not for legal purposes, not as a confession, as a document, a record. A piece of paper that said, "This happened, and we know it happened, and you know it happened." And the story that was told in this family about sacrifice and generosity and everything we gave up is not the complete story. My father signed it on a Tuesday morning. He did not look at me when he signed it. I did not need him to. I also did something I had not told Diane I was going to do until 2 days before the settlement closed. I wrote a check, not for $200,000. Not from guilt or obligation or the 30-year weight of a debt I did not actually owe. For $30,000. Directed specifically to a partial payoff of the business's highest interest debt obligation, the one that was causing the most immediate cash flow pressure. Structured as a loan, documented with a promissory note at a fair market interest rate with a 7-year repayment schedule. Not a gift, a transaction, with terms, with documentation. With the professional structure that any financial relationship between adults deserves, regardless of whether they share a surname. Diane looked at me when I told her. "You don't have to do this," she said. "I know," I said. "That's why I'm doing it." There is a version of this story in which I am cold. In which the girl who drove to Naperville with a legal file and a retained attorney and 20 years of compounded math is a person who has let precision replace warmth. Who has allowed the professional habit of documentation to calcify into something unforgiving. I have considered that version. I don't believe it. What I believe is this: the most loving thing I could do for myself, and honestly for my parents, was to refuse to participate in the fiction any longer. The fiction that sacrifice is a currency that accrues without limit. The fiction that love, expressed through provision, generates perpetual debt. The fiction that the story of a family is the story the most powerful members agree to tell. My parents did sacrifice things for me. That is real. The years of running a business, the physical labor, the anxiety of ownership, the genuine effort to create a stable life, that is real, and I do not dismiss it. What they also did was make a financial decision in 2004 that redirected my future without my knowledge or consent, and then construct, over the following 20 years, a narrative of sacrifice that drew on that decision for its emotional weight, while the decision itself was never disclosed. That is also real. Both things can be real. That is, I think, the most difficult lesson of adult relationships with parents, that the people who love you can also harm you, not from malice, but from the specific blindness that comes from believing that love grants unlimited jurisdiction over another person's resources, choices, and story. My parents believed that. They believed it so completely that they sat across from me at a dinner table with a $200,000 ask and the language of sacrifice and did not, for a single moment, consider that I might be in possession of information that reframed everything they were saying. They did not consider it because, in their model of our relationship, I was still the child who received. I had become, at some point in the previous 20 years, something different. A person who documents, a person who retains counsel, a person who drives to Naperville with wine and helps set the table and waits, with extraordinary patience, for the conversation to become what it actually needs to be. I want to say something to every person who has been handed the debt of someone else's choices and told it was love. You are allowed to audit the books. You are allowed to request the records, to review the history, to ask the questions that the family climate has always rendered too cold to ask. The guilt they deploy is real, in the sense that you will feel it, genuinely and painfully, because you love them and you do not want to be the person who dismantles the story they have told. I felt it. I felt it in the car on the drive to Naperville, and I felt it at the dinner table, and I felt it in the settlement meeting watching my father sign a document with his eyes on the table. But guilt and debt are different things. Guilt is an emotion. Debt requires documentation. And when someone asks you for $200,000 on the basis of sacrifice, the professional, adult, self-respecting response is to ask, calmly, precisely, without drama, for the accounting. Show me the records. Show me where the money went. Show me which sacrifices were for me and which ones were for you and which ones I was used to justify. My parents could not show me. The records showed me instead. And when I sat at that table and said the number, $380,000, I was not performing. I was not being cruel. I was doing the thing I had been trained to do for 15 years of professional life. I was reading the document aloud. I was making sure the number was in the room. Because numbers, unlike guilt, do not shift under pressure. They stay exactly what they are. And what mine said was, you were not the debt. You were the asset. Act accordingly. The business stabilization plan launched in March. The promissory note is current. The signed acknowledgement is filed. My father called in April. We talked for 11 minutes. It was the most honest conversation we have ever had. Guilt is an emotion. Debt requires documentation. Request the records, read them carefully, then decide what you actually owe. If you have ever been handed someone else's story about sacrifice and told it was your invoice, if you have ever felt the weight of a debt you never agreed to carry, leave one word below: audited. That's all. And if someone in your life is still sitting with a guilt they didn't earn, still trying to love their way out of a debt that was never real, send this to them today. Because the records exist, and what they say is yours to know.